Welcome to the next installment of my video lecture series for economic analysis of the law here at Rutgers University in Camden. And this is the week number 12. It's also partially a week number 11 overview. So this video will be in week 11 and in week 12. And this one deals with chapter 11, an economic theory of the legal process. And the items that are talked about and are important in this chapter are the notion of contingent fees. If you realize there are only a few countries that allow lawyers to construct their payment contract with their clients on a conditional or contingent basis. The condition is typically that the client wins the pending litigation or a settlement. Realize that there are some countries that allow this to occur, and they include the United States, United Kingdom, Australia, Belgium, Brazil, Canada, the Dominican Republic, France, Greece, Ireland, Japan, Lithuania, and New Zealand, and that the European Union is considering allowing contingent fees in a limited number of circumstances. For years, most legal systems made it illegal for an attorney to make his fee conditional on the outcome of litigation or other legal resolution. Whatever the moral reasons for this restriction, it is not a practice that meets with economic favor. We hope this section explains that contingent fees are efficient. So hopefully you understand why contingent fees are efficient. Additionally, the chapter goes over some additional behavioral considerations. One of them that it goes over is hindsight bias. And realize that hindsight bias suggests that if someone is asked to make the determination knowing that an accident has occurred, in fact occurred, and that someone who was injured, it proves impossible for the determiner to put him or herself back into the same position that the original company was in prior to the accident occurring. So what behavioral economics tells us is that if we know that an accident occurred, it is difficult for anybody that's being an arbiter in this situation to be asked what was reasonable before the accident occurred. Realize that instead the facts that an accident has happened, that someone was injured, and that the victim has initiated a lawsuit are significant enough to cause anyone trying to look at the behavior before the accident to revise upward their prior expectations of an accident taking place, and thus giving some level of precaution. So just realize that the behavioral aspects that pop into economic analysis of the law. Additionally, there's some discussion about the empirical evidence on dispute resolution. And in this section, they talk about empirical studies in this particular edition of the textbook. It contains a lot of information, and it is important to go over this. We strongly that you bring, at least you have some notice of two of the important sections in this particular part of the textbook. The notion of selective litigation, the Priest-Klein model, the 50% rule, and the empirical literature that seeks to identify the characteristics of the relatively small fraction of disputes that actually go to trial. And two, the summary of Professor Mark Gallanter's article, The Vanishing Trial. So make sure there's two components you feel comfortable with. And finally, there's a section on the empirical methods in the law. This is one of the more important developments in legal scholarship that has occurred recently. So this is a recent development, and there's quite a bit of empirical scholarship going on. Unfortunately, there's no routine or common knowledge among many of the law and economics students, law students in particular, about empirical methods. As a result, many of the readers of this edition of this book might not be able to handle this, but make sure you understand just the notion of what's going on and the increased use of empirical methods when we're talking about economic analysis of the law.